The case of the people of the state of Colorado versus James Egan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Mr. King, Ms. Brady, Ms. Nelson, Ms. Spengler, and Ms. Higgs. And the prosecution is represented by Mr. Brockler, Ms. Pearson, Ms. Stitch McGuire, and Mr. Edson. The record should reflect that we're outside the presence of the jury. Is Mr. Orman here today?
He is. He'll be joining us a bit later, Judge.
All right. Well, I have a few things on my list to talk to you about outside the presence of the jury. The first one is on the notebook, which has been introduced into evidence. And can anyone remind me what the exhibit number on the notebook is? Does anyone know off the top of their heads?
I can.
All right, thank you, Mr. King.
It's 340.
All right, P-TR-341. It occurred to me last night that arguably the notebook is subject to the limiting instruction that I have given the jury with respect to other evidence such as Dr. Reed's testimony, Dr. Metzner's testimony, the videotaped interview by Dr. Reed, the defendant, and Dr. Fenton's testimony, and then evidence that has been introduced as each of those witnesses has testified. I know that initially in this litigation there was a disagreement as to whether the notebook was subject to the physician-patient privilege, and eventually the parties decided, I think, that they didn't want to have to resolve that issue if they could avoid it, because it appeared to be an issue of first impression, at least in Colorado, if not beyond Colorado. And what I ended up ruling, I think on June 4th, when the defendant entered a not guilty by reason of insanity plea, is that I didn't have to decide the issue, because if it was subject to the privilege was waived as a result of the plea. And if it was not subject to the privilege, then the notebook should be disclosed to the prosecution anyway, and frankly to both parties. So, but given that that's out there, I'm asking the parties if they want me to give the jury the instruction that I've given with respect to the evidence that I mentioned a moment ago in terms of the notebook. And neither side asked me to give that instruction when the notebook was introduced, but we could still give it to the jury. We're still in the middle of the trial. The jury, I'm sure, is familiar with the notebook by now, both because both parties made it clear in opening statements that this was a significant piece of evidence in the case, and also because it's been talked about quite a bit. And so I think that not only the notebook, the contents of the notebook, but any testimony related to the contents of the notebook. And for the most part, I think it's been testimony from the sanity experts. So do the people have a position on that, Mr. Orman?
If the defense would like that instruction, we do not object to it.
Okay. Does the defense want me to give that instruction?
Yes, Your Honor, and we seem to recollect that you gave that instruction before, but as I think about it, maybe it was relating to testimony by the expert about the notebooks.
I think that's right.
But we agree with the court and would ask for that instruction to be given.
All right, I will give it. Mr. Edson, what exhibit number are the records related to the fitness center that we spoke about yesterday?
The membership agreement is 1094A, and the usage detail by customer is 1094B.
All right, it's 1094B, P-TR-1094B that the defense objected to yesterday on discovery violation grounds or on Rule 16 grounds, and I overruled the objection, and I implied, and now I'm making clear that there is a technical violation, but that I found that no sanctions are warranted. And so let me just supplement the record with some legal authority. Discovery sanctions serve the dual process of protecting the integrity of the truth-finding process and deterring prosecutorial misconduct. That's from People versus Acosta, A-C-O-S-T-A, 338 Pacific 3rd, 472. That's a case from the Colorado Court of Appeals from 2014. Therefore, a trial court should impose the least severe sanction that will ensure full compliance with its discovery orders and protect the defendant's right to due process. In determining an appropriate sanction for a discovery violation, the trial judge should consider, number one, the reasons why disclosure was not made, number two, the extent of the prejudice, if any, to the opposing party, and number three, the feasibility of rectifying that prejudice by a continuance and any other relevant circumstances. That's from People versus District Court, 808 Pacific 2nd, 831, Colorado Supreme Court case from 1991. The fact that a prosecutor had no actual knowledge related to the discovery violation is not a defense, but is a consideration in fashioning an appropriate remedy under Rule 16. That's People versus District Court, 793 Pacific 2nd, 163. That's a Colorado Supreme Court case from 1990. In fashioning a sanction to achieve the goal of eliminating the due process violation, a court must strive to restore as nearly as possible the level playing field that existed before the discovery violation. That's again from the District Court case that I mentioned, 808 Pacific 2nd, 831. In Acosta, the court addressed the appropriateness of excluding evidence as a discovery violation. The court stated as follows: in considering sanctions, a trial court should be cautious not to affect the evidence to be introduced at trial or the merits of the case any more than necessary, and should, if at all possible, avoid excluding evidence as a means of remedying a discovery violation because the attendant windfall to the party against whom such evidence would have been offered defeats rather than furthers the objectives of discovery. Thus, exclusion of evidence is an inappropriate sanction where exculpatory evidence, although inadvertently withheld prior to a preliminary hearing, was revealed prior to trial. That's the end of the quote. Where a sanction is not designed primarily to deter improper behavior, the goal must be to cure any prejudice resulting from the violation. That's again from Acosta. Absent a showing of prejudice resulting from the discovery violation, there is no reversible error. That too is from Acosta. Accordingly, when a continuance or a recess in a trial in progress will cure the prejudice to the defendant, the trial court should go no further in crafting a sanction to address a due process violation. So yesterday, I considered, number one, the reasons why the disclosure was not made, and I specifically explained that it appeared to me, based on the record made, that this was inadvertent, and it appeared that this was something that fell through the cracks, but given the magnitude of the case, and given all the witnesses and potential witnesses involved, and the voluminous discovery involved, and the length of the trial, that I thought it was frankly understandable, and I expressed how pleased I have been that there haven't been very many Rule 16 issues that have come up in this trial. There was no allegation of prosecutorial misconduct or bad faith at all on behalf of the prosecution. Number two, the extent of the prejudice, if any, to the opposing party, and I found that there was no prejudice to the defense, and I made the record about that. There are 5 attorneys on each side of the aisle in this case. The material was provided to the defense more than 3 months ago, so the defense has had plenty of time to prepare for the material, to prepare to cross-examine the witness in question, the custodian of records, and also to respond to any of the evidence presented through that witness. And then 3 was the feasibility of rectifying that prejudice by a continuance and any other relevant circumstances. There was no prejudice in my mind, and so there was no need to think about any other remedy. I said that the exclusion of the evidence was inappropriate, and I continue to believe that that would be a drastic remedy that's not warranted in this case. Now, if the defense wanted to ask for some other type of remedy, I would consider it. For example, if the defense wanted to endorse a witness out of time, late, in order to respond to this evidence, I would allow it. Or if the defense wanted to use evidence that perhaps has not been discovered in a timely fashion, I would entertain that in order to respond to this particular evidence. If the defense wanted additional time to prepare to cross-examine this witness, I would entertain that. If the defense wanted additional or wanted to allow one of its experts to testify about opinions that have not previously been endorsed, specifically related to this evidence, I would entertain that as well. Those, I think, would be remedies that the court could entertain that would not be as drastic as exclusion of the evidence and that would not interfere with the truth-finding process. So I wanted to supplement the record in that fashion. The next issue I have on my list is a scheduling issue. It occurred to me yesterday that if the prosecution finishes on Friday, and it sounds like you're anticipating that you may, and I want to remind you that Friday is a short day. We have to end at 3:30. But if the prosecution is thinking that it is going to rest its case on Friday, even with the short day on Friday, there is a potential option that I wanted to just ask the parties about to see if they were interested in it. And I'm not saying that I favor one over the other. I'm just asking whether you have a preference. We could take Friday off. It's going to be a short day anyway. Come back on Monday, have the prosecution rest on Monday, and then take Tuesday and Wednesday off. So that's one option. The other option would be to just go through, have the prosecution rest on Friday, and then take off Monday, Tuesday, and Wednesday. But I would like to be able to tell the jury what we're doing so that they can plan ahead. Now, when I say take the days off, it's possible that I may ask you to come in one of those days so we can get some work done, perhaps start talking about instructions. So when I say off, I mean off for the jury. We may have to come in. I'm not anticipating that you're going to come in all 3 days, but I may ask you to be here on one of those days, or at least one of you. For example, if Ms. Nelson is going to be in charge of instructions, then she can be here. The rest of her colleagues don't have to be here if they don't want to be here. And similarly with the people, whoever's going to be in charge of instructions can be here, and we can start chatting about instructions perhaps. But if you want to give that some thought, you don't have to give me an answer now. I just would like to be able to tell the jury soon what the plan is in terms of scheduling. Does that make sense?
Your Honor, Ms. Tish McGuire tells me that I think it would create witness issues to go into Monday. I think one of our witnesses for Friday is just not available on Monday. I think that our preference is just to finish our case on Friday, and I think even with the short day, we anticipate doing that.
All right. Is it anything the defense wants to add to that?
No, thank you.
All right. Is it okay with both of you if I tell the jury then that we're planning on taking Monday, Tuesday, and Wednesday off next week?
We don't object, Your Honor. I mean, it's always possible, some witness gets in a car crash or something, and therefore they're not available for the rest of this week. So I don't want to promise them something and then we have to
Right.
change things. But I don't object to that as long as the court says that's what we're planning on, but it's not 100% certain.
I'll make sure it's tentative. Is that okay with the defense as well?
Yes, Your Honor.
Okay. All right, would Ms. Nelson and Mr. Orman please approach for just... why don't council approach? I think I have a different idea. right. We're talking about juror number 267. There was a request by the defense to dismiss juror 267 back on May 6th of 2015. And this was the day after Ms. Carbonell testified. That's Carbonell. And what happened was, as I recall, Ms. Carbonell testified for the prosecution and on May 5th. And the next day, the prosecution indicated to the court that Ms. Carbonell had recognized one of the jurors as someone she knew, and that it was juror number 267. And so the next day, that day that the prosecution informed me about this, in other words, the day after Ms. Carbonell testified, which would have been May 6th, I brought in juror 267 alone and questioned her individually. And what I asked her is, have there been any witnesses that you have recognized? And she said, oh, I think it was a lady named Carbajal. She couldn't remember the name. To be clear, exactly what I asked her is, to be precise, I just have a question for you. The question is, have you recognized any witness who has testified thus far? And the answer was, I did recognize the woman that, and then she asked, can I give her name? And I said, yes. And then she said, I think it was Carbajal, who was the mother of the boy that went to the school that I work at. And given those answers and given some of the other answers she gave me that day, it was clear to me that she recognized this witness, Carbonell, and in fact, the witness had mentioned her son during her testimony. And so I think it was clear to her that this is the woman whom she knew from school. She had mentioned her child, an individual voir dire, as one of a couple of kids at her school who was getting treatment. She had said that there were a couple of students in her school. This was juror 267, who works as some kind of clerk at a middle school. She had mentioned an individual voir dire that there were a couple of kids at school who were getting therapy. One of them as a result of having been in the theater during the shooting, and the other one as a result of having a brother who was in the theater during the shooting. And that she had observed these kids being picked up, dropped off and picked up from therapy, I think was what she told us during an individual voir dire. Well, Ms. Carbonell specifically mentioned her son during her testimony here in court, and juror 267 heard that, and she told me about that when I spoke with her individually on May 6th. And so it's clear to me that she recognized this witness and didn't say anything. And then when I spoke with her, she made it sound like she just didn't recognize Ms. Carbonell because Ms. Carbonell used to wear glasses, and then that threw her off. But given the testimony of Ms. Carbonell, and given that Ms. Carbonell mentioned her son, and given what this woman, juror 267, had said to us about during individual voir dire, I'm convinced that she was not completely forthcoming with me. So the request by the defense to dismiss her is granted. There was a request made on May 6th by the defense, and I defer ruling. There were two requests made for relief by the defense on May 6th. I defer ruling on both of those. And I said that they were not right for ruling. And then there was a different request made yesterday. I am granting the request that was made yesterday on the grounds that were raised yesterday. I am denying the request that was made on May 6th because, taken at face value, the answers that juror 267 gave me when I spoke with her alone here on May 6th do not cause me concern and do not warrant either of the requests made by the defense. They do not warrant the relief that was requested, either of the two types of relief requested by the defense on May 6th. So since I defer ruling on that request on May 6th, I'm ruling on it now. Both of the requests on May 6th by the defense are denied because, taken at face value, juror 267's statements to me here in court when I individually spoke with her do not warrant either of the types of relief that the defense requested. if I take her statements at face value, which I did on May 6th and which I do now, I wouldn't be excusing her. The request that was made yesterday was based on the allegation that she was less than forthcoming and completely candid with me. And now that I've gone back and looked at my notes and looked at the individual voir dire and looked at everything else, I agree with with what Ms. Nelson said yesterday here at the bench, and so the request is granted. By the way, this same juror on May 19th recognized an officer, Officer Ben Holston, who apparently works at her school, and I questioned her related to that, and there was no request made by either side with respect to that issue. So, so that the record is complete. So what I'm going to do is I'm going to bring her in, and I'm going to inform her that she's been released. Would you please get Juror 267? The record should reflect that juror number 267 is now present in the courtroom. Good morning.
Good morning, I think.
I brought you in because I need to inform you that I have decided to excuse you. This is related to the issue that came up on May 5 with Ms. Carbonell, when Ms. Carbonell testified, and then I think we brought you in the next day on May 6, and I questioned you individually about that. There was a request made at that time by one of the parties, and I deferred the request. But there was another request, a different request made by one of the parties yesterday, and that request I have granted. And the grounds that I granted it on is that going back and looking at the notes and looking at what we talked about during individual jury selection, I don't believe you were completely forthcoming and candid with me when Ms. Carbonell testified. I think Ms. Carbonell recognized you and she told us about it. And then it's when she told us about it that you and I ended up having a conversation on May 6th. So I'm going to go ahead and release you. I thank you for your service. Unfortunately, we kept you on from May 6th up until today, but the request wasn't made until yesterday. The request that I'm granting was made yesterday, and I ruled on it today, and I've granted it today, and therefore I'm dismissing you today.
Okay.
All right.
All right.
I should let you know that I've ordered the media not to talk to any of the jurors as long as the case is pending, the proceedings are pending, even jurors who have been discharged. And so I'm making the same request of you that you not talk to the media, okay?
Okay.
And you've heard me say to the jurors that they cannot have any contact with any jurors who have been excused. So
Right.
I'm going to make the same request of you. Please don't contact any of the jurors at all about anything, okay?
Okay.
Will you do that for me?
Yes.
All right, thank you. I appreciate that. So
Okay.
do not have any contact with them in any way until after the trial proceedings are over. Once they're completely over, then you can have any contact you want. Same thing goes for the media, please. Don't have any contact at all until the trial proceedings are completely over. After that, you can do whatever you wish, okay?
Okay.
All right, my staff will escort you out. Thank you.
Thank you.
What?
Sorry.
That's okay. All right. All right, is there anything that we need to talk about on behalf of the people at this time?
I have some items, but I'll just do that at the break.
Okay, anything we need to talk on behalf of talk about on behalf of the defense?
Judge, I have two things, and I'll just tell the court what they are, and then if the court wants to wait to discuss these, that's fine with me.
Okay.
First one is I anticipate that Ashley Mosier will be testifying soon, and I anticipate a number of objections, and I talked with Ms. Teach McGuire and told her it would probably be most efficient if I did that before she testified. I don't think she objects to that, so at some point I would like to do that. And then also, the court asked us that if we ever wanted to attempt to interview any of these excused jurors, to let the court know, and we would like to talk to the court about that.
Okay. All right. Can that wait, or do you want to talk about it now?
It can wait.
Okay. Why don't we wait on that? And then what about the issues with respect to Ms. Mosher? Is she testifying anytime soon?
Your Honor, I anticipate that she would testify on Friday, Your Honor.
On Friday? Okay, so we have time on that as well.
Thank
All right,
you.
Thank you. What number is the highest number of court trial exhibit that the parties have used that we haven't made a record about?
It's one of the records I was going to make. I've used 62 through 66 that I'm going to make the record on later, Judge.
All right. Has the defense used 67 or anything beyond 66?
No, I don't
No?
think we have.
All right. I'm going to mark the instruction that Ms. Nelson, Ms. Stitch McGuire, and I, the proposed instruction that the three of us talked about on Monday, which the defense has up until now told me that they do not want me to give it to the jury. I proposed it in case the defense wanted it, and I said I wasn't tied to this particular language, and that I was happy to hear suggestions about other language or a different instruction. And I'm still happy to entertain that, but I'm going to mark the proposed instruction as a court trial exhibit, and we'll mark it as court trial exhibit number 67, okay? All right, let's bring the jury in, please. Here you go, Ms. Robinson. Let's mark that as C-DR-67. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Good morning, folks. How's everyone doing? Thanks for your patience. A few things before we get started. First, a scheduling thing. We're a little bit ahead of schedule, and so we may be taking a couple of days off next week, the beginning of the week. I'm telling you so that you can plan ahead. I don't want to make it a certainty because something may come up. You never know. But right now the plan is tentatively to take Monday, Tuesday, and Wednesday off, okay? And so I'm sure you would appreciate some time to catch up on things that maybe have fallen behind for you because you've had to be here. I don't see a lot of sad faces as I'm talking to you. So, and of course, as you know, as you may have expected, I'll give you a lengthy discussion of the advisements right before the end of the week if we do that. But that's at least the plan. That's number one. Number two, I have excused another juror. Please do not speculate about that and do not draw any inferences from that, all right? You're not allowed to speculate or guess why that juror was released. The third thing is, and this is a substantive thing, there has been discussion and introduction of a notebook. And what exhibit is that again? 341. Okay, P-TR-341, the spiral notebook that was introduced into evidence. I need to give you an instruction that applies to the notebook, and it's the same instruction that I've given you with respect to all the testimony of Dr. Reed, all the testimony of Dr. Metzner, all the testimony of Dr. Fenton, the videotaped interview of by Dr. Reed of the defendant, and any evidence that has been introduced through these folks, including yesterday through Dr. Fenton. There were a couple of exhibits introduced, and as you know, the instruction applies to that evidence as well. Well, the instruction also applies to the notebook and any testimony that has been given with respect to the notebook. The court admitted the notebook and the testimony related to the notebook only, to the contents of the notebook, only for a limited purpose. You may consider this testimony only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. And I remind you folks that when I refer to the issues raised by the defendant's plea of not guilty by reason of insanity, I mean the issues related to the following two questions. Number one, whether the defendant was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act. And number two, whether the defendant suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an element of a crime charged. And I have explained to you before that the prosecution has the burden of proving each and every element of each crime charge beyond a reasonable doubt. One element of each and every crime charge in this case is the element of sanity. In other words, the prosecution has to prove beyond a reasonable doubt with respect to each crime charge that the defendant was not insane at the time of the commission of the act. And so the notebook and the contents of the notebook and any testimony related to the contents of the notebook can be considered by you only with respect of that one element that the prosecution has to prove beyond a reasonable doubt, the element being that the defendant was not insane at the time of the commission of the act. You cannot consider it with respect to any other element of any crime charge. Does everybody understand that? Yes. And everybody's saying yes and nodding their head yes. Great. All right. With that then, I'm going to turn it over to Ms. Teach McGuire so that she may call her next witness.
Thank you, Your Honor. I am going to call a witness who actually has a longer name than me. Bonnie Kate Pouchot-Zoigby, please.
Okay. Actually, we can have a chair. Can you get up there? Are you okay? All right. Good morning.
Good morning.
Let me have you raise your right hand for me so that I can administer an oath, please. you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Could you please tell us your full name for the record?
Bonnie Kathleen Pusho Zogby.
All right. Could you please spell all of your names? And could you do so after you move the microphone really close to your mouth? You are soft-spoken, and I'm afraid we're not going to be able to hear you unless it's right next to your mouth.
Is
so
that
could you please spell your names?
BONNIEKATEPOURCIAU Zogby, COGHBI.
Ms. Tishma-Wire, you may proceed.
Thank you. Good morning. Were you at the Century 16 movie theater in Aurora, Colorado on July 19th and 20th of 2012?
Yes, it was.
What were you doing in Colorado that day?
I was on a road trip with my friend Elizabeth Summerall, and we were traveling, just passing through for the day.
So you just happened to be in Aurora, Colorado that night.
Yeah.
Why did you decide to go see Batman?
It was kind of a last-minute decision. We were going to go hiking, but the place where we were going to go hiking, all the wildflowers were not blooming because there was a really bad drought. So we went to our hotel room early, and we're just brainstorming of things to do. And the lady at the front desk was like, well, you could go see a movie. There's one not far. And that's how we went to go see it.
What time did you arrive at the movie theater that night?
I don't remember exactly, but we arrived pretty early, like maybe 30 or so minutes before the movie started.
How did you go about finding your seats in the movie theater?
That's actually the funny thing. I went to go sit kind of towards the front, and my friend Elizabeth was like, no, let's sit up here. So we ended up sitting about in the middle of the theater.
I'm going to approach the witness with what's been marked for identification as People's Exhibit 1251.
Yes.
All right, I'm going to hand you a pen, and if you could do me a favor and write your full name on there, please, today's date, and then also if you could put a BK for Bonnie Kate and an ES for Elizabeth Summerall about where you two were seated in the theater that night.
Just circle.
And then if you can just put your initials for which seat you were each in. All right, Your Honor, may I approach?
You may.
Right, and then if you could also just circle those seats for me, and if you could
yeah.
put today's date, which I think it's June 17th. All right. That's okay. Your Honor, this time I'd move for the admission of People's Exhibit 1251.
Is there any objection?
No objection.
All right, without objection, P-TR-1251 is admitted and may be published.
Thank you, Your Honor. And with the court's permission at this time, I would ask for the witness to be able to join me up at the 3D model.
Okay. Are you going to hold the microphone?
I am going to hold the microphone for her, Your Honor. All right, I'm going to ask you to kind of stay back here with me. Otherwise, we kind of block the jury's view a little bit.
Yes.
All right, okay. So if you could please point out to the jury where you were seated.
We were seated probably about right here.
And where were you and where was Miss Summerall?
I was on the left side and she was on my right side.
Could you please tell the jury about what you recall happening in your theater that night?
Yeah, so about 15 minutes into the movie or so, I saw something go across the screen, and at first I thought it was somebody messing around or just being silly, and then I started to hear gunshots, and I ducked down right away, and my friend Elizabeth, she was frozen in her seat, and so I grabbed her hand and pulled her down beside me, and in the midst of all that, while we were on the floor, there was screaming and smoke and shots being fired, and I then felt a big bang in my left knee, and it jolted my entire body.
I'm going to ask you some follow-up questions.
Yeah.
Could you show the jury where it was that how you got down and where you were when you got down?
Yeah, so if I was about right here, I just ducked down behind the seat and kind of curled up into a ball, and then I looked and saw her there, so she was just sitting frozen in her seat, and then I grabbed her hand and pulled her down, like, beside me. Yeah.
Did you ever see a figure of a shooter in the...
I did not. I didn't.
Did you ever see any flashes of gunfire?
No, I saw smoke, but I don't remember seeing actual flashes.
Do you recall where you saw the smoke?
Towards the front, but it kind of seemed smoky everywhere, honestly, but when I was on the ground, I couldn't see much.
Please describe for the jury what it felt like when you were hit.
It's kind of funny. It felt like a big 2x4 board just like smacked me, and my whole entire body just absorbed the impact of it and moved me.
What were you thinking after you'd been hit?
Objection to relevance.
Overruled.
You can tell the jury.
Okay. Honestly, this is going to sound crazy, but I felt peace. I've never felt the amount of peace that I did in that moment when I thought I wasn't going to make it and I thought I wasn't going to live. I just felt like God wrapped me up, and I wasn't scared. It was weird in the midst of all that horror. God was really near to me.
What do you recall happening next after you were down on the ground?
Well, there was okay. So after I was shot, I grabbed for Elizabeth's hand, and I was extremely calm for some reason. So Elizabeth didn't know that I had been shot. So I grabbed her hand and I started praying out loud, and it wasn't because I wasn't hurting. It was just I felt this crazy peace, and so I reached for Elizabeth's hand and started praying, and we lay there for a little while, and then there was a pause in the shooting, and that's when my friend Elizabeth got up and ran, and she didn't know that I couldn't get up and follow her. So she ran, and I tried to stand up, and my knee just completely buckled under me, and so I was like on the ground kind of trying to army crawl towards this exit over here, or like get up to this aisle, and I was scared I was going to get trampled. Everyone was, panicking and scared and running out.
What happened after you were trying to army crawl to the aisle?
God sent someone to help me. A man named Chris Lakota. He saw me on the ground and decided to help pick me up, and kind of like arm in arm like this, carried me out the top and downstairs to the lobby. And my friend Elizabeth saw us from the back, and she thought that...
I'm going to object at this point to the narrative as well as to hearsay.
The objection as to hearsay is sustained.
All right. So you were able to reunite with your friend Elizabeth?
Yes.
Okay. What happened when you got out to the lobby?
Objection to relevance in 403.
Overruled.
They helped carry me outside to the front of the theater, and they laid me down on the front for a little bit, and it was crazy chaotic, and I was bleeding really bad, and so they...
Were you able to observe your injuries at that point?
Yeah, even in the theater, I couldn't see it, but I was feeling to try to see what happened and how bad it was, I couldn't really see anything until I was outside, but yeah.
Please describe for the jury what you saw.
Well, my knee was gushing blood, kind of like a wine bottle, just like glug glug, like a whole bunch of blood was going everywhere, and I was, trembling with pain. I wasn't crying at that point, though. I felt a sense of peace about me. But on the concrete where they carried me out to, I bled all over that, and then that's when Officer Nigel came.
And I interject an objection at this point, Your Honor, to relevance in 403. I'd also ask if we're finished with the model that we take our seats.
Okay.
Well, the objection is overruled.
Thank you, Your Honor. Can I just have her finish this question, and then I'll have her go back to the witness stand, Your Honor?
Yes.
Okay, if you could just tell the jury what happened when Officer Nigel came.
Yeah, it was such a wonderful blessing because he let me use his phone, and I was able to call my parents and tell them what happened. And then they like stopped the bleeding a little bit, wrapped up my leg, and they moved me around to the other side to where there were like cop cars and ambulances and stuff to try to get people out.
All right, at this point, I'm going to have you go back to the witness stand.
Okay.
Thank you. All right, were you able to be transported for medical attention?
Yes, thank goodness I was. The policeman that night really saved my life. I know for a fact I wouldn't.
An objection at this point to 403.
Okay.
In relevance.
I don't know that it was responsive. Ask your question again. The question was, were you able to be transported for medical attention? Actually, she answered it. She said yes, so I'll sustain the objection. Ask the next question, please.
How were you transported?
I was transported in a cop car. The ambulances were full.
Were there any other people in your police car with you?
Yes, there was an Indian couple behind me, I remember.
If you could just pull that microphone a little bit closer to you again. Thanks.
Sorry.
Sorry about that. Please tell the jury what hospital you went to.
I think it was the university, but honestly, I'm drawing a blank. I don't remember.
You're not from Colorado. Please tell the jury about what injuries you sustained as a result of the shooting.
Well, I was shot in my tibia plateau where my knee comes together, and it kind of mushroomed inside, which caused an abrasion in my artery, which formed a flap. So the blood flow to my left knee was shut off by the time I got to the hospital, and I had big fasciotomies on both sides of my leg, and they had to take my saphenous vein to repair my popliteal artery on the back of my knee to be able to save my leg. And then I've had multiple surgeries since then, like repair surgeries and manipulations and stuff to try to help with the pain. But yeah, 7 so far.
How many surgeries in total have you had?
7.
At one point in time, did you have a plate and several screws placed into your leg?
Yeah. I had a big plate and 10 screws in my leg.
Object at this point to relevance in 403.
Overruled. It goes to the nature and extent of the injury.
You can continue telling the jury.
Okay, so before I had the plate put in, I had a big external fixator put in to stabilize everything until I was able to have the plate put in. And then I had to have the plate removed because they thought it would help with my pain, and sadly it didn't. And then I had another surgery in LA where they took stem cells from the bone marrow in my hip and injected in my knee to try to help, and also burned some of my sensory nerves there, and it didn't help either. But yeah, I've had lots of surgeries and procedures.
All right, this time, if I may approach the witness with what's been marked as People's Exhibits 4607, 4605, 4606, 4608, and 4610.
Yes.
Thank you.
Please take a look at those photographs. Do those photographs fairly and accurately represent some of the injuries you sustained on July 20th of 2012?
Yeah, they represent some of them because these are all pictures of right at first, but I've had a lot of procedures since then that were equally traumatizing and painful.
All right, this time I would move for the admission of People's Exhibits 4605 through 4608 and 4610.
Is there any objection?
There is, Your Honor. May we approach?
Yes. All right, the objection, well, there's an agreement now as to 4605 and 4608. So by agreement, neither one of those photographs is admitted. The other photographs are all admitted and may be published.
Please have 4610. All right, please describe for the jury what they see here.
So this is right after my reconstruction surgery. The big gash with the little metal part that you see, the kind of shiny part, that's the head of the plate that they put into my knee. And then the black, kind of like Frankenstein-looking scar is one of the fasciotomies. I had another one on the other side as well. And I don't know if you can see on the back, but at the very bottom under my knee, that's like on that side is where they had the artery repair, where they repaired my popliteal artery, and you can kind of see it right there.
And there's a mouse in front of you. If you could, it's hard to manipulate, but if you could try to kind of point that, yeah, it's very tricky.
Right there.
If you could kind of point out for where that artery repair was. Perfect, thank you. If I could please have 4606. All right, please describe for the jury what they see here.
Okay, so this big, I'm bad at this mouse. This big black thing, that's this bar is was the external fixator that was put in to stabilize everything, because my knee was just totally shattered and destroyed, and there was so much swelling, like they couldn't repair it right away. So they had this bar screwed in. I had 2 screws at the bottom and 2 at the top that just mobilize everything. And then this big black thing you see right here, that is where my fasciotomies were, and that black thing's called a wound vac, and it sucks out the excess fluid to try to help the swelling go down, because you know, all that trauma just made my leg huge, and so they had us cut it to let out the fluid.
Thank you. And if I could have 4607.
Okay, so this is actually back in Baton Rouge, and this was before my reconstruction surgery still. And at the top you can see right here, that's the external fixator from a different viewpoint. These, right, I can't get the mouse on it, but like this is where I was shot. I was shot with this bottom one is where the bullet actually went in. All the other things that you see were scopes that were done. And then these 2 big things on the side, those are the fasciotomies after they took out the wound vacs and closed them back up. And you can't see, but there's scars on this side of my leg for where they repaired the artery on the back side. There's a big scar on the back side too.
Thank you. Please tell the jury how old you were on July 20th of 2012.
I was 18 years old.
Will you need any future surgeries as a result of the shooting?
Objection, Your Honor, to 401, 403, due process.
I'll allow this one question. I think it goes to the extent of the injuries.
Thank you, Your Honor.
Yeah, sadly, I will need a lot more surgeries probably. I'm going to have knee replacement eventually, but I'm too young to have it now, and they don't last very long, so my doctor wants me to wait as long as possible before I get it. But if I get it now, I'll have to have another one when I'm 40, another one when I'm 60.
Interject another objection.
All right, sustained.
Thank you very much, Your Honor. I have no further questions for this witness.
All right, Mr. McGuire, do you want to retrieve these 2
Yes,
photographs?
thank you, Your Honor.
Is there any cross-examination, Ms. Pengler?
No.
And the jury does not appear to have any questions. May this witness be released from her subpoena?
Please, thank you, Your Honor.
Is there any objection?
No.
All right. Ma'am, thank you.
Thank you.
Thanks, Monica.
Ma'am, thank you.
Thank you.
Thanks, Monica.
Call your next witness, please.
Aline Young.
Good morning. Good morning. Can I I have you raise your right hand for me so that I can administer an oath? Do you solemnly swear or affirm on the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. Please tell us your full name and spell your first, middle, and last names.
It's Alleen Elizabeth Young. That's ALLEENELIZABETHYOUNG.
All right, Ms. Teach McGuire, you may proceed.
Were you at the Century 16 movie theater in Aurora, Colorado on July 19th and 20th of 2012?
I was.
Who did you decide to go to the movies with that night?
My friend Stephanie Davies.
Why did you decide to go see the movie?
We just didn't really have anything else to do.
Was the summer?
Yes.
How old were you on July 20th of 2012?
I was 19.
What happened when you got to the movie theater that night?
Well, we got there really late because it was a last minute decision. So we just kind of had to pick the only two seats that we could find together. We didn't really have time for food or anything, so we just ran in and sat down as the previews were going.
How full was the movie theater?
As far as we could see, it was packed except for the two seats that we found.
Your Honor, if I may approach the witness with what's been marked for identification as People's Exhibit 1252.
Yes.
Ms. Young, I'm going to ask you to go ahead and write your full name on there, and also today's date, which is June 17th of 2015. And if you could write your initials in the seat you were at and the initials of your friend Stephanie Davies, where she was sitting.
Okay.
May I approach the witness, Your Honor?
You may.
Thank you very much.
Thanks, I have no objection.
All right, and Ms. Spangler just told me she had no objection to the admission of People's Exhibit 1252.
And are you moving its admission?
I am, thank you, Your Honor.
All right, without objection, it is admitted.
All right, with the court's permission, may Ms. Young join me at the 3D model, Your Honor?
Yes.
Thank you, and I'm going to ask you to grab that microphone, Ms. Young. All right, could you please tell the jury where you were seated and where Ms. Davies was seated?
Sorry. Okay. I was sitting right here in the aisle seat, and she was to my right.
All right, please tell the jury about what you recall happening in the theater that night.
About 15 or 20 minutes into the movie, I heard a loud noise that sounded like either someone like kicking in a door or just like a louder like metal bang. And I looked to my far right corner because there's an exit down there, and I saw the door open and someone walk in that kind of looked like he came from Call of Duty.
What is Call of Duty?
It's a video
I'm going to
game.
object to the characterization.
Hold on. And there's an objection.
403.
Sustained.
Right, could you please just describe what that figure looked like for the jury?
Just all black with a mask and maybe some like body armor.
Anything else that you could see about that figure at that time?
Just it was really dark in that corner, so it just looked like a big black metalled blob.
What do you recall happening after you saw the figure come into the theater?
Just kind of stood there for a little bit, so I wasn't really sure if it was someone like leaving or coming in. And then I saw a canister kind of fly behind me a couple rows, so I ducked a little bit because I heard like a weird hissing noise coming out of it.
What do you remember happening after the canister?
I remember hearing some people not really screaming, but just kind of like shuffling or like talking just in my back where it landed. So I turned up and looked over my left shoulder to see like what it was or what people were doing behind me. And then I just heard a really loud noise and I blacked out.
What's the next thing you remember after you blacked out?
I woke up and there were people running on top of me. And my friend, because I had fallen into the aisle seat, and I tried to push myself back to like the seat area.
I'm going to interrupt you for a second. I apologize. Could you show the jury on here where you had landed?
Yeah, I just fell like right into this aisle seat, like next to my seat. And then I tried to crawl to like where underneath the seats, like where your feet would be. And my friend was able to help me get underneath there.
What happened after you were able to get back into the aisle and avoid being trampled?
She tried to get me to stand up, and I realized that I couldn't. My entire like right side of my body just wasn't responding. And then I realized that I couldn't breathe. So I just kind of laid there and tried to find a position that I could breathe.
Why were you not able to breathe at the time?
I had been shot in my neck and also in my lungs, so I was pretty like choking and drowning on my own blood.
What do you recall while you were down on the ground?
I just remember Stephanie calling 911 when she realized that I couldn't stand up. And then when she saw, I just, like I said, tried to find a position that I could breathe. And then when she turned her attention to me and saw what had happened, she came over and put her hand on my neck because she saw I was bleeding so much.
What do you remember after that?
We just laid there for a couple minutes. I just remember telling myself that I had to keep trying to breathe. Stephanie's hand was just on my neck and she was just staying with me. And then after a while, the lights came on and she just told me that I had to stay there and be quiet.
Could you hear anything in the theater while you were down on the ground?
I kept hearing a lot of noises, but it was really hard because the movie was playing, so it sounded like distant gunfire, but then also the occasional like really close, loud gunfire, but it was a little bit hard to distinguish between the two.
What were you thinking while you were down on the ground?
Objection to relevance.
I was just thinking that I had to breathe because it was just such a struggle.
How are you able to get out of the theater?
After a couple of minutes of just lying on the ground, and after the lights came on, a couple of police officers came through the exit right next to us, and they were just telling everyone that we had to get out. So I still couldn't stand, so I kind of had to crawl over to the aisle to this railing to help lift myself up, and then kind of hobble out of the theater through this exit.
What happened when you left through this exit?
We got out to like the lobby area in the theater, and there were just more cops telling us, like ushering us to get out of the theater. So I just kind of had to lean on Stephanie and hobble out to the exit.
All right, at this time I'm going to ask you to retake your seat at the witness stand. Thank you. What do you remember happening after you got back into the lobby?
In the lobby, I just remember there just being a bunch of police officers and people just running and yelling.
Where did you go after you got into the lobby?
Just outside the theater.
What do you recall happening when you got outside the theater?
I'm going to object at this point to 401, 403 in due process.
Sustained. Ask a more specific question if you want.
Did anyone come over to help you with your injuries at that point in time?
Yeah, not at first. I collapsed outside the theater because I couldn't walk anymore. And then a man, his name's Todd, came and just picked me up in his arms and carried me to the nearest where he thought like an ambulance would be.
How long did you wait there for medical treatment?
Objection, 401, 403.
Overruled.
I was in the parking lot just sitting on the concrete for maybe 5 to 10 minutes.
Were you transported for medical treatment?
Yes.
Please tell the jury about how you were transported.
I was in an ambulance.
Do you recall if there were any other people in the ambulance with you?
There were 2 more people.
What hospital did you go to?
University.
What happened when you got to University Hospital?
I was put on a gurney in the ambulance, so they had to kind of like wheel me out, and then they just put me in a little hallway because everywhere.
To 401, 403. I have no objection to the specifics of her injuries.
All right, sustained.
Please tell the jury about what injuries you sustained as a result of the shooting.
I had shrapnel from the shotgun. I had pieces in my neck, one that severed my carotid artery, and then I had a couple that hit my arm, and then ones that went through my right side to my lungs, my liver, my kidney, and also 2 in my heart.
Do you know how many pellets in total you had in your body?
Initially about 35.
How many were they able to remove?
So far only like 5 or 6.
Your Honor, if I may approach the witness with what's been marked as People's Exhibits 4655, 4656, 4657, 4658, and 4659.
Yes.
Ms. Young, do you recognize those photographs?
I do.
Do they fairly and accurately represent the injuries you sustained on July 20th of 2012?
They do.
Your Honor, at this time, I'd move for the admission of People's Exhibits 4655 through 4659.
Is there any objection?
Your Honor, there's no additional objection to 4656. I would object to 4658 as cumulative to 4657.
Right, can I see that, please? Give me just a moment, please. All right, the objection to 4658 is sustained under Rule 403 because I find that the probative value of the photograph is substantially outweighed by the unnecessary presentation of cumulative evidence. Would counsel please approach with respect to P-TR-4656? All right, P-TR-4656 is admitted based on the reasons stated in amended order D98B, and also because I am overruling any objection to cumulative under Rule 403. And all of the pictures that are admitted may be published. So that means
Everything.
P-TR-4655, 4656, 4657, and 4659.
Thank you, Your Honor. Can I please have 4655? Okay. Ms. Young, could please describe for the jury what they're seeing in this photograph?
That's me after I had my surgery to cauterize my artery.
Right. If I could please see 4656. You could show, if there's a little mouse that's up there, if you could point that to your neck and show what was happening at that point in time with your neck.
Okay, well you can't really see, but that's where I was injured, and I assume that they're trying to insert a breathing tube.
And where exactly on your neck were you injured, if you could show the jury?
Just right here on my right side. You can't, like, kind of where the blood is coming from.
Right. Please have 4657. Please describe for the jury what we see here.
These are the shrapnel that hit my back.
Right. If I could have 4659. Please describe for the jury what you see here.
This was, again, after my surgery, so these are just what the shrapnel scars look like afterwards.
All right, thank you. How many, please describe for the jury where the pellets still remain in your body.
I have...
Object to relevance in 403.
Overruled. It goes to the permanency of the injury.
I still have about 30 in me that range from like the bottom of my head all the way to the back of my, I guess like my lower back. So 2 in my heart still, in my arms, my neck, my back.
Were they able to remove the ones from your liver, lung, and kidney?
No, they just left them in there. The muscle or the organs kind of just accept them and grow around them.
Do you know if you're going to have any other future surgeries as a result?
Objection 401, 403 due process.
Overruled. Same reason. It goes to the extent of the injuries.
I'll most likely have to have more surgery.
Do you know what for?
Just to remove more of the pellets.
I have no further questions for this witness. Thank you, Your Honor.
Is there any cross-examination?
No.
And the jury does not appear to have any questions for this witness. May she be released from her subpoena?
Please, thank you, Your Honor.
Any objection?
No.
All right, thank you, ma'am.
Yep.
Joyce. Go. Ms. Teach McGuire, here's the picture that was not admitted.
Thank you, Your Honor.
Yep. All right, members of the jury, it's 10 after 10, so let's go ahead and take our morning break. Please make sure that you follow all my advisements related to your conduct when you're not in the courtroom during this break. They all apply, and I will see you back here at 10:30 in about 20 minutes. Thank you. Enjoy the break. All right, please be seated, everyone. The record should reflect that the jury has exited the courtroom. Is there anything we need to talk about before we take our break? Mr. Edson?
Thank you, Judge. Your Honor, I'd like to first go through the C-TR exhibits from yesterday. So I'll be tendering back to the court C-TR 6-2. This is a Gander Mountain surveillance video from May 22nd, 2012, there was testimony put forth by Carla Rodriguez from Gander Mountain. That was not introduced. CTR 63 is a transaction journal from Gander Mountain from July 1st, 2012. There was some testimony from Andrew Barrowback about that particular exhibit.
And why don't you mention the people's exhibit numbers for
Yes,
each,
sir.
just so that the record is clear.
Thank you. CTR 62, which again was the Gander Mountain surveillance video, that was originally People's Exhibit 532. The transaction journal of July 1st, 2012 was originally People's Exhibit 1100. We've now marked it as CTR 63. Originally People's Exhibit 795, this is now marked CTR 64. These are the pages, Your Honor, from, this is Point Loma, records from yesterday. These are the January through April, as well as that August 2012 that the court spoke about yesterday. It was not introduced as that part of the exhibit, but because we had discussion about it, I wanted to mark it as a court trial exhibit. Original People's Exhibit 1173 is now marked CTR65. This is Ms. Tish McGuire's exhibit from yesterday. Jameson Toes, the Theater 9 diagram. Originally People's Exhibit 361 is a Gander Mountain surveillance video that was initialed and talked about by Andrew Barrowback. It has now been marked as CTR66. Finally, on this issue, Judge, I do have, the court recalls from Mr. Barrowback's testimony that we were agreed to redact some handwriting in People's Exhibit 1102. We've done that now, and I'd asked during the break that my paralegal be allowed to swap out the pages, and we will mark that other one as a CT exhibit as well. But I asked that the court leave for that process to be done, and I have shown this to counsel as well.
Okay, great.
Finally, Judge, the next witness will be Diane Mathis. She is a custodian of records for USAA. It's the credit card, MasterCard in this case. I spoke with Ms. Higgs yesterday, and she had some suggested redactions that I agreed to and I've already done, so we don't have to have this conversation with the court. Exhibit 793 will be the USAA exhibits. The requested social security number for the defendant, we went ahead and redacted that from page 1 and 2, which would be discovery pages 4501 and 4502. There were 2 entries within the exhibit itself, page 4602 and page 4614. Both of them dealt with, one was a red light payment, and the other was for a court payment of sorts. Ms. Higgs requested that be redacted, and we've done so. So I think that takes care of all the redactions related to that. My last thing, Judge, I spoke again with Ms. Higgs. I know we had a bench conference yesterday before the Point Loma witness testified regarding an instruction to the jury about redactions. I quite honestly could not remember if the court read that. She believed that she did, so I trust Ms. Higgs on that. I don't know if there's a position as to the same type of thing regarding this exhibit.
I did read it, and I'd be happy to read the same instruction if the defense wants it.
Yes, please.
Okay, I will give it. Thank you.
That's all that I have, Your Honor. Thank you.
All right, thank you. Is there anything on behalf of the defense that we need to talk about?
Your Honor, just briefly so the court can, if it wants to review this over the lunch hour, I have reviewed this exhibit that Mr. Edson just spoke about. I have confirmed that the appropriate redactions are in there. I do make a general 401, 403, and 802 argument if the court wants an objection to that. The court wants to review it to respond to that so we don't have to interrupt the testimony. Your Honor, I'd also request, if possible, that with regard to the bank records that, and I don't know if the court has released the bank records from yesterday to the public, I would request, because of the sensitive nature of some of the information that's in these, that these not be released to the public if that's at all possible.
Okay. All right, thank you. Any response to the 401, 402, and 403 objection to B-TR-793?
I do have a copy for the court if the court would like to take a look at it
Sure.
during the break, so I'll bring that to the court. I can make my argument now or after the court reviews it.
Why don't you make it now?
I do believe, Judge, that this is, first of all, I would note that I limited this exhibit to the same time period that the court requested the Point Loma time period be, so it's essentially May of 2011 through July of 2012. So all of these transactions, and I'll incorporate a lot of my argument from yesterday for Point Loma, but all of these transactions relate to transactions made by Mr. Holmes of this particular account. The court has heard extensive evidence from numerous retailers, both online and physical brick and mortar retailers, about this particular MasterCard ending in 2217. We do believe that it is relevant, that there is not, that the probative value is not substantially outweighed by the danger of unfair prejudice. And related to any cumulative argument, again, as I stated yesterday for Point Loma, this is the actual transaction itself. It also shows payments towards this particular account. We heard testimony about that yesterday from Point Loma, but there's also information about the payments of this account as well. So we would respectfully request that that be denied. May I approach with a copy of this?
Yes, please. Thank you. All right, Ms. Brady, do you want to address your request to speak to jurors who have been dismissed? Or is it just a request that you want me to consider? In other words, do you want to, anything you want to add to that, or do you want to just make the request?
Well, Judge, as the court's aware, normally we don't have to make the request. We're just doing it because the court asked us to, if we intended to contact these excused jurors, and we would like to contact them. We think we have the right to contact them. I don't know what the reason would be why we couldn't, so we do request that.
All right, do the people have a position on that, Mr. Orman?
We object, Your Honor. I've never actually heard of an attorney trying to contact an excused juror in the middle of trial. It seems to me grossly improper to do so. The questions being asked, I presume, would be, hey, what do you think? What's the good evidence? What's the bad evidence? What are we missing? How can we change our trial strategy mid-trial based on your expertise as a juror? You know, attorneys ask questions of jurors after the trial is over, and that is a normal thing to do, and I think we've all done that many times. But obviously, if the defense is going to go contact the jurors, we as diligent attorneys are going to go do that too. I have a feeling jurors might consider that somewhat harassing in the course of the trial, and I think the court should say no to this request.
All right. Yeah, the request is denied. I have some concerns about doing this in the middle of trial. In a way, it would be providing the attorneys a window, if you will, into the jury and what's going on with the jury, and I think that's improper during the trial. You know, jurors have certain specific knowledge that the attorneys don't have, for example, about each other and each other's lives, each other's preferences. So even if you're not asking about this case or what they're thinking about this case, you can get all kinds of information about jurors who are still here in this trial and who are still part of this trial. You can get information about their personal lives and some of the things they like, some of the things they don't like, from jurors who have been dismissed, and I don't think that's appropriate while the trial is ongoing. I think it would give the attorneys an opportunity to get information about the jurors who are still here that I don't think they're entitled to have during the trial, and I don't think it's appropriate for them to have during the trial. And I'm also worried about some of the concerns expressed by Mr. Orman in terms of trying to get an idea about what attorneys should be doing differently or the same trial strategy, that kind of thing. And for all those reasons, the request is denied, and I'm ordering counsel both sides. I'm ordering the attorneys on both sides and their staff to not contact the jurors. I will add the jurors who have been dismissed. I will add that I have told the jurors not to talk to, or I have asked them not to talk to the media about this case, not to contact jurors who are still here. That is to say, I have requested that the jurors who have been dismissed not have any contact with jurors who are still here, and that they not have any contact with members of the media. I've also ordered members of the media to not contact any jurors who have been excused until the proceedings are completely over. And I don't think it would be fair to allow the attorneys to have access to those dismissed jurors during the trial in light of all that, and I don't think it would be appropriate either for all the reasons I stated. So the request is denied, although I appreciate Ms. Brady bringing that up to my attention. All right, with that, we're going to take our break. I will review Exhibit P-TR-793 during the break. The court will be in recess. Thank you. Please rise.